take a look at what else is happening on the corridors of justice. And another three-judge bench is making a ruling on the constitutionality of the Affordable Housing Act. The judges will also rule on the legality of the housing levy. That is Justices Olga Sewe, John Chigiti and Josephine Mongare, who make up that three-judge bench. A very emotive issue. Let's cross over live and listen in.
49, 50, 52, 53, 54, 59, 60, 61, and 62. So we've set out those particular provisions. And the articles of the Constitution alleged to have been violated are 1, 2, 3, 10, 19, 20, 21, 24, 27, 28, 29, 36, 40, 43, 46, 47, 48, 50, 93, 94, 109, 129, 131, 153, 159, 160, 185, 186, 187, 258, and 259. So there's therefore a link that was shown by the petitioners, the aggrieved parties, between the provisions that have been complained about, the provisions of the Constitution alleged to have been contravened, and their allegations as to the manifestation of the contravention. And in this regard, we again reiterated the provisions, the holding of the Supreme Court in the Commission's Communications Commission of Kenya versus the Royal Media. So we further find that the respondents were able to deduce and comprehend the case against them, the issues raised by the petitioners, and were able to respond in detail and with particularity to each and every one of those issues. Therefore, we are of the view that roundly considered, the petitions meet their narrator Karimi threshold. We bear in mind that in Mumo Matemu versus Trusted Society, the Court of Appeal said that precision is not coterminous with exactitude. We've relied on a quotation from that particular decision. Accordingly, we find no merit at all in the respondents' contention that the petitions do not meet the requirement of specificity. Moreover, Rule 10.3 and 4 of the Mutunga rules state that the court may accept an oral application, a letter, or any other informal documentation which discloses denial, violation, infringement, or threat to a right or fundamental freedom. An oral application, that's now 4, shall be reduced into writing by the court. As noted by Justice Muita, in addition to allegations of violations of rights under Article 22, the petitioners also alleged inconsistencies between certain provisions of the various provisions of the Act and the Constitution. And in this regard, Article 258 is explicit that every person has the right to institute court proceedings claiming that this Constitution has been contravened or is threatened with contravention. We have also quoted the other provisions of that particular article. So we are in full agreement with the position taken by Justice Muita in the ruling dated 3rd May, and we quote from paragraphs 50 to 54 that Article 165 confers this court with the jurisdiction to determine whether any law is inconsistent with or in contravention of the Constitution, the question whether anything said to be done under the authority of the Constitution is inconsistent with the Constitution. We've quoted those paragraphs. Now, in connection with the doctrine of avoidance, we referred to Communications Commission of Kenya, and we've quoted also from that decision, that the principle of avoidance entails that a court will not determine a constitutional issue when the matter may properly be decided on another basis. The Supreme Court relied on a South African decision, and we've basically quoted from the decision of the Supreme Court, paragraphs 256 and 257. Similarly, we relied on KKB and SCM and others. The court had the following to say, and we quoted from it. In summation, the doctrines of ripeness and constitutional avoidance shun to deal with a constitutional issue where there exists another legal cause which can give the litigant the reliefs he seeks. In other words, a constitutional issue is the only cause that can give the litigant the remedy he seeks. Both constitutional avoidance and ripeness avert the determination of the constitutional issues until it becomes necessary, to the extent that it is the only cause available to assist the litigant's cause. End of quote. We also relied on Farage and 3 others versus Police and 2 others to support that doctrine. So then what was our conclusion? Having acknowledged that the predominant issue is whether the provisions of the Affordable Housing Act are in conflict with the Constitution, it is our considered view that that doctrine of avoidance is inapplicable to the petitions as consolidated. I'll invite my colleagues to consider the first, to read our judgment on the second issue, and that is whether the Act is constitutional or not, and they'll share that both Justice Mungare and Justice Chigiti.
Having disposed of the technical points, we now turn our attention to the merits of the petitions. The brief background is that by a judgment of this court, differently constituted, various provisions of the Finance Act 2023 were declared unconstitutional. One of the nullified provisions was Section 84 of the Act, which sought to amend the Employment Act in the following terms. And I quote Section 84 of the said Act. The Employment Act 2007 is amended by inserting the following new sections immediately after Section 31A. Insertion of new section of number 11 of 2007, Affordable Housing Levy, that 1B, notwithstanding the provisions of Section 32A, B, C, and D of the Act, each employee and employer shall pay a monthly levy to be known as the Affordable Housing Levy. 2. The purpose of the Affordable Housing Levy shall be to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as the provisions of affordable home financing to Kenyans. 3. The Affordable Housing Levy shall not be used for any other purpose other than development of affordable housing and associated social and physical infrastructure, as well as the provisions of the affordable home financing to Kenyans. 4. The monthly levy payable by the employer and the employee shall be A. 1.5% of the employee's gross monthly salary for the employee and 1.5% of the employee's monthly gross salary for the employer. In the judgment aforementioned, the court expressed the view that Section 84 proposed to introduce a new levy known as the Affordable Housing Levy without a proper statutory framework to govern the imposition and administration of the levy. Accordingly, the court held that the provision was in conflict with Article 210 of the Constitution. The provision was therefore declared unconstitutional. However, the court granted stay pending the enactment of a substantive legal framework. It accordingly ordered as follows: that the introduction of the housing levy through amendment of the Employment Act by Section 84 of the Finance Act 2023 lacks a comprehensive legal framework in violation of Articles 10, 201, 206, and 210 of the Constitution. The imposition of the housing levy against persons in formal employment with the exclusion of non-formal income earners to support the national housing policy is without justification, is unfair, discriminatory, irrational, and arbitrary, and in violation of Articles 27 and 201 of the Constitution. The fourth respondent proceeded with speed and published the Affordable Housing Bill, number 75, by Kenya Gazette Supplement number 236 of 4th December 2023. It was proposed, processed and passed on the 21st February. The bill was thereafter of 2024. The bill was thereafter forwarded to the Senate on 12th March 2024, and upon being passed was given presidential assent on the 19th of March 2024. Sections 4 and 5 of the Act became operational immediately by dint of Section 1A of the Act. It was on the same date that the President appointed the chairman of the board. The rest of the provisions were operationalized on 22nd March 2024 by a special issue of the Kenya Gazette Supplement number 70 of 21st March 2024 through Legal Gazette number 54. The court takes judicial notice pursuant to Section 85 of the Evidence Act that following the operationalization of the Affordable Housing Act, the respondents proceeded to implement the Act by Gazette Notice number 4350, 4351, and 4351 of 12th April, and Gazette number 4495 of 17th April 2024, where the CS Lands appointed members of the board. It was the operationalization of the Act that precipitated the filing of the petitions. It is trite that statutes enjoy the presumption of constitutionality, and thus the onus was on the petitioners to establish that the impugned Act is indeed unconstitutional as alleged. We bear in mind that the burden of proof is on the petitioners to prove all the aspects of their petitions to the requisite standard. The Supreme Court, in the case of Samson Gwel and 5 others, versus Kenya Medical Research Institute and 3 others, stated as follows, and we quote from paragraph 47 of that judgment. It says, "It is a timeless rule of the common law tradition, Kenya's juristic heritage, and one of fair and pragmatic conception that the party making an averment in validation of a claim is always the one to establish the plain veracity of the claim. In civil claims, the standard of proof is the balance of probability. Balance of probability is a concept deeply linked to the perceptible fact scenario. So there has to be evidence on the basis of which the court can determine that it was more probable than not that the respondent bore responsibility in whole or in part." This position was reiterated by the Supreme Court in Wamwere and others versus the Attorney General, and we have cited the holding of the Supreme Court, which said a petitioner bore the burden to prove his or her claim of the alleged threat or the violation of the rights and freedoms of the requisite standard, which was on a balance of probabilities. Such claims were by nature civil causes. The onus of proof was on the first appellant to adduce the sufficient evidence to demonstrate that she owned or erected or lived in the alleged properties, and that state agents interfered or deprived her of the subject properties. That was the import of Section 107 of the Evidence Act on the burden of proof. End of quote. We further cite the decision in the Council of County Governors versus the Attorney General by the mastiff judge, as he then was, and I will not read that, but we have lifted a bit of the ruling on the general presumption that every act of parliament is constitutional and the burden of proof lies on every person who alleges otherwise. Further, in the East African Court of Appeal, in the case of Danambo versus the AG, the court held that the Constitution is a living instrument, having a soul and a consciousness of its own. Courts must endeavor to avoid crippling it by construing it technically or in a narrow spirit. It must be construed in tune with the lofty purpose for which its makers framed it. Fundamental rights have to be interpreted in a broad and liberal manner, ensuring that our people enjoy their rights. Our young democracy not only functions but gross, and the will and dominant aspiration of the people prevail. End of quotes. The guiding principle in determining whether the sections of an Act of Parliament are unconstitutional were succinctly laid out in the case of Institute for Social Accountability and another versus the National Assembly, where a three-bench of this court held as follows. First, that this court is enjoined under Article 259 of the Constitution to interpret the Constitution in a matter that promotes its purpose, values, principles, and advances rule of law, human rights, and fundamental freedoms in the Bill of Rights, and that contributes to good governance. In exercising its judicial authority, this court is obliged under Article 159 of the Constitution to protect, promote the purpose and principles of the Constitution. Additionally, we also looked at the petition of number 150 of 2016, which was consolidated with petition number 234 of 2016, Attorney General, E.G. and others versus Attorney General, where the three-bench judge held that the technique of paying attention to context in statutory construction is now required by the Constitution. As pointed out earlier, the Constitution introduced a mandatory requirement to construe every piece of legislation in a manner that promotes the spirit, purport, and objects of the Bill of Rights. The purpose of statute plays an important role in establishing a context that clarifies the scope and intended effect of a law. The often quoted dissented judgment of Schreiner J.A. eloquently attributes the importance of context in statutory interpretation and he went on to say that certainly no less important than oft-repeated statement that the words and expressions used in a statute must be interpreted in according to their ordinary meaning in the statement, and that they must be interpreted in light of their context. But it may be useful to stress 2 points in relation to the application of this principle. That first is the context, as here used, is not limited to the language of the rest of the statute regarding as throwing light of a dictionary kind or of the part to be interpreted. Often of more importance is the matter of the statute, its apparent scope and purpose, and within limits its background. We further cited the case in SBM and another versus the Attorney General. It's a Supreme Court decision that states that it's unassailable that the approach to interpreting fundamental rights and freedoms in the Bill of Rights by this court has to take the model of looking at the Constitution as a whole, which is purposive and generous, giving effect to the constitutional values, including substantive equality. In reaction to inequality and discrimination advanced by the petitioner in Prinsloo versus Vanda, this is a South African decision, where the court said it is convenient for descriptive purposes to refer to the differentiation presently under discussion as mere differentiation. I'll not quote the end of that ruling, but I'll go to the next broad issue. Under the broad issue of constitutionality, we identified the following points for determination. 1, whether there was adequate public participation. 2, whether the Affordable Housing Act violates Article 27 and 40 of the Constitution. 3, whether the Act infringes on Article 43 of the Constitution. 4, whether or not the Act amounts to a clawback on devolution. 5, whether the use of public land for development of affordable houses infringes on the functions of the National Land Commission. And 6, whether the Act is unconstitutional for failure by the CRA to consider the bill as per Article 205(1). On whether public participation was undertaken, the petitioner has argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best what was done was a cosmetic exercise and a waste of public resources. The petitioners argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioners argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days was too short, and thus the purpose of public participation cannot be said to have been achieved. Similarly, they contend that the deliberations of the Senate at the second and third reading stages was also constrained, with the result that it limited public participation to 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the discrimination of the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioners submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties, while the National Assembly executes its mandate in 290 constituencies. The petitioners further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioners also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioners urged this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. In their response to this question on public participation, the respondents did not dispute that public participation is a requirement of the Constitution. To illustrate, the National Assembly indicated that it conducted civic education in languages comprehensive to the diverse communities in various locations before public participation sessions were conducted by providing fact sheets that gave information to the Affordable Housing Bill. In addition, advertisements in the local daily newspapers were done inviting the public to submit views on the bill by the deadline of 28 December 2023. Key stakeholders were invited to participate to make oral presentations before the committee in sittings that were held in Parliament buildings on 29 and 30th January 2024, 6th and 7th February 2024. The respondents submitted that public hearings by key stakeholders were held on diverse dates across 19 counties.
So that you don't regionalize.
Those are live proceedings from the Milimani Law Courts there as the three-judge bench Comprising of Justices Olga Sewe, John Chigiti and Josephine Mongare rule on the Housing Levy Act, whether it was enacted constitutionally. We'll be taking you back to the Milimani Law Court there as we listen to more of the decision of the court. And this is after former Attorney General Githu Muigai submitted on behalf of the Land and Housing CS that Parliament conducted public participation and gave the necessary legislative mechanisms for the enactment of the law. And so the court will this afternoon decide whether the Affordable Housing Act, which is the law anchoring President William Ruto's pet project, is constitutional. They will be ruling on 6 cases that were filed challenging the law and the affordable housing levy itself that was imposed at a standard rate of 1.5% of the gross salary of an employee, or even the gross income of a person that a person has received or accrued. And this is for those who are not employed. And so we'll continue to listen in to that bench. Of course, the government defending the affordable housing program, submitting that the initiative is designed to meet the critical housing needs of Kenyans. We had the Cabinet Secretary for Lands during the submissions of the cases. They are arguing that the Act sought to fulfill the constitutional right of every Kenyan to adequate and accessible housing as well. We'll be taking you back to the Milimani Law Court. Let's hear from the lawyers in studio, Titus Mahanu as well as Kefa Ojijo. Gentlemen, as we await the 3-judge bench ruling on the impeachment of impeached Deputy President Rigathi Gachagua, Kefa, what do you make of what has been said so far by the 3-judge bench with regard to the constitutionality of the housing levy?
Number one, you remember the reason why this matter was filed ideally was arising out of 2 issues. Number one, FKE had moved to court challenging this matter on the ground that, number one, there was no public participation involved. The employers were never involved in this process. They were not questioned. Stakeholders did not give their opinion. The government just came with its own figures and imposed on people. Number two, the Employment Act itself, I think Section 37, already provides for an employer to provide the employees with the housing. So the question of housing is already addressed in the Employment Act. Then there was a question now before the court, where now you're again bringing another question of the housing levy, which already has been taxed or already has been taken care of by the Employment Act. I mean, is there a conflict of laws now in itself, number one? Will there be a conflict of laws? And then number two, was the process constitutional in the process? That now there was no clear public participation. So these are the major issues that the court will be, definitely be dealing with and probably decide. Because in the in time when the court should pronounce that the 2 issues raised were not clearly addressed before the government went ahead with the process, then it means the process will therefore be a nullity, and therefore the housing levy will then be thrown out. Right. Without
and we've seen the government side saying they did do sufficient public participation. But Titus, what are the legal arguments now, in your view, that support the constitutionality of the Affordable Housing Act?
Now, what I do recall, and basically this is what I can pick out from what is happening, the argument that has also been proffered is that the Housing Act is discriminatory in the sense that it only targets those employees drawing salaries as opposed to other people. Yet this is supposed to be a project that targets everybody, because they seem to have packaged in such a way that everybody has to contribute. So employees have moved on the basis that it's discriminatory. It only targets people who are employed to the exclusion of the rest. Mm-hmm. So those are the constitutional issues that I can pick up. But then as to whether it will be thrown out or not, we can only wait and see what the court will say. Right,
but we saw public participation happen, and this was a big conversation. Did the public participation that took place, in your view, fulfill the constitutional requirements for this kind of legislation?
Now, the concept of public participation has been deliberated on by courts not once but on numerous occasions. And the threshold is so high. It's just like the adage, the way the adage goes, that the law needs to be, justice ought to be seen to be done. So even public participation, you have to ensure that it is not superficial. It has to be manifestly seen to be done, such that it is reasonable. in the eyes of any reasonable man, someone can reasonably deem that actually there is public participation. But public participations whereby it involves a few individuals, where a few people are put in a room and then they say this is it, that does not amount to public participation. You can imagine like the public participation that we saw happening in the case of the impeachment process. You can see it was marked with a lot of chaos here and there. That cannot be said to be public participation. Public participation needs to be serious, and the courts have rendered their decisions on the issue.
Right. When it comes to public participation, there was many questions with regard to the division of functions, but I understand the court is still in session. Let's cross over live and listen in.
And 201 of the Constitution, while in the appeal case, the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda, but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47 and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. B, facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the Nucleus, South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Moiko Basin versus Moiko Basin local community and 15 others versus the Permanent Secretary, Ministry of Energy. And we cite a quotation where the court said public participation does not dictate that everyone must give their views on an issue of environmental governance. To have such a standard would be to give a virtual veto power to each individual in the community to determine the collective affairs. The question that must be answered by this court is whether an opportunity was afforded to the public to air their views on the implementation of the Affordable Housing Act. This is as per the threshold set by the decision of the Supreme Court in the case of British America Tobacco, PLC versus the Cabinet Secretary for Ministry of Health, Kenya Tobacco Alliance, and another, and Mastermind Tobacco, where the Supreme Court in this decision said that, and I quote, public participation has been entrenched in our Constitution as a national value and as a principle of governance under Article 10 of the Constitution, and is binding on all state organs, state officers, public officers, and all persons whenever any of them A. applies or interprets the Constitution, B. enacts, applies or interprets any law, or C. makes or implements the public policy decisions. As aptly stated by the Appellate Court, public participation is anchored in the principle of the sovereignty of the people that permeates the Constitution, and in accordance with Article 1.4 of the Constitution, is exercised both at national and county levels. The court went further to reiterate this principle in the case of Aura versus Cabinet Secretary, Minister of Health, and the National Assembly has argued that the invited members of the public to take part in the exercise, which was conducted by the Joint Committee of the Department on Finance and National Planning and the Departmental Committee on Housing and Urban Planning, Public Works and Standing Committees on Roads, Transport and Housing, respectively. Both committees have demonstrated through their reports annexed as SN1 to the affidavit of Samuel Joroge, the clerk to the National Assembly, and JN1 to 3 of the Senate that support the assertions that the public and various stakeholders were invited and their views were taken into account before Affordable Housing Act was enacted. Herein below is a chronology as enumerated by the two affidavits that initial reading and committee referral that the Housing Bill number 75 was introduced to the National Assembly on the 7th of December 2023. The bill was subsequently referred to the Departmental Committee on Housing, Urban Planning, as well as the Departmental Committee on Finance and Planning. That on the 9th of December 2023, the clerk of the National Assembly published a notice in the local newspapers inviting the public to submit memoranda. This notice was issued under Article 118 of the Constitution and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the clerk of the National Assembly was valid, dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that the public participation, that is in the Kisumu case, had been properly conducted. We note that on the The National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the Joint Committee. This is to be found in the affidavit of Samuel Njoroge, Clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Njoroge and marked as SN1. The bill underwent the second reading on 15th February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The ASAND report, which is annexed to the pleadings, details a report of the session of 15th February, which is attached to the pleadings here as SN2, and the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, Clerk of the Senate. We note that the Senate conducted, through its Committee of Transport, Housing, also sent invitation to key stakeholders to appear before the committee for public hearings on 1st March 2024. The invitations were marked and annexed to the Senate's response as JN2. The Senate Roads and Transport Housing Committee reviewed the memoranda and stakeholder submissions. After considering various proposals, the committee's recommended that the bill be adopted with the proposed amendments. These views were annexed to the Senate's response marked as JN3. On 12th March 2024, the Senate passed the bill with amendments. The bill was then transmitted to the President for assent, which took place on the 19th of March. It cannot be denied from the foregoing that the public participation was conducted. As shown, the National Assembly and the Senate focused on very targeted and specific stakeholders, in particular the petitioners. We note that the petitioners took issue.
The fourth will be Honorable David Munyi Madenge. Fifth will be